This, another example of the IRS going after regular business people with no proof of wrongdoing. The latest case comes from Iowa, where the owner of a cash-only Mexican restaurant had her checking account seized, all because she deposits less than $10,000 in cash at a time on a regular basis with her bank. Judge Napolitano, still here. We are going to agree on this.
We are. But this is really a terrible statute and a terrible interpretation of it. And here's the backstory. The statute formerly prohibited willfully structuring your deposits so that they were under the $10,000 limit. Because as everyone probably knows, if you deposit $10,000 or more in a bank account, the bank, not you, the bank is obliged to report that to the IRS and other regulatory authorities of the federal government.
Yep.
So a lot of people wanting to avoid that were depositing $9,999.99 over and over again. So Congress wrote a statute prohibiting the willful depositing of it. First person convicted under this statute was convicted in federal court, upheld in the Circuit Court of Appeals, conviction thrown out by the Supreme Court of the United States because the Supreme Court said willfully means willfully intending to violate the law, not willfully intending to make the deposit. What did Congress do? Remove the word willfully from the statute. So now anybody who willfully, negligently, or ignorantly makes deposits slightly under $10,000 is presumed, on a regular basis, is presumed to be violating the law, and the IRS can seize that money until the decision is made whether or not to prosecute them.
Well, let's bring up a case that you and I discussed on this program some time ago. It's the story that we had earlier. We had a woman on the show, earlier this year actually. Her family's grocery store in Michigan was targeted by this IRS law, if you want to call it that. Just listen to the lady. Did they seize everything that you'd got in the account?
Yes.
What did they say to your dad when he was in the store?
They accused him of money laundering, and they asked him why he made deposits, cash deposits, the way he did. He answered their questions, and they said they've seized his bank account.
Now, Judge, it took that lady months to get her money back, and she was responsible for the legal costs of getting her own money back.
Yes. The government does not reimburse your legal costs unless, except under certain narrow circumstances. And this is
it's outrageous.
Truly outrageous. The story in the New York Times yesterday about which you spoke, this woman is effectively out of business. It wasn't a great deal of money. It was $35,000, but it was her entire operating account.
Yep.
She couldn't pay her employees. She couldn't pay her vendors. She couldn't pay her landlord as a result of what the IRS did with no evidence of criminality whatsoever.
The IRS now says it will curtail the practice, but not end it. In other words, it's still in force.
I blame the IRS. But more than that, I blame the Congress for removing that word willfully. The word willfully ought to be in every federal statute. The government should have to prove the willful intent to violate the law so that innocent people are not ensnared in the zeal to prosecute.
I would go much further. Congress should have said, you take their money, you got to tell them that you're taking it, you got to tell them why you're taking it, and you got to bring it before a judge.
Let's put it this
way. What's wrong with that?
In this country, the money should not be taken before conviction.
Thank you.
No one should pay any penalty who is still innocent. That's been the law in the United States and in Great Britain for at least 750 years. Enough said.
You go about that far. Is that Magna Carta?
Yes.
Thank you.
You're welcome.
I'm glad your knowledge of British history is up to speed. Thank you very much indeed, Judge Napolitano.
1215 Magna Carta.
Yes, King John.
Reluctantly signing it.
He was forced to.
Yes.
Are we done?
We are.
Where was it signed? Arundel. You didn't know. All right. Check the big board.
Runnymede.